5, 4, 3, 2, 1. Apparently, the state felt some difficulty in implementing the interim direction of the full bench. The difficulty was felt, according to the state, in working out the proportion as indicated by the full bench. The state therefore sought a clarification or modification of the direction. The full bench clarified the order. The court made it clear that the court had not intended to fix any particular percentage with respect to any class or category constituting the 50% sum total of the reservation. Based on the established norms and applicable parameters, it was open to the state to fix the appropriate percentage of quotas with respect to each individual class and category as it may objectively and fairly decide, constituting some total of 50%. We may notice here that the two sets of writ petitions before the full bench related to appointment and admission to educational institutions. A quota for admission to educational institution was fixed by an executive order at 73%. That had also to be reduced to 50% pending final decision by the full bench. The full bench had postponed the final decision to await the decision of the Supreme Court in view of the pendency of the case before that court. The state therefore issued another direction or an executive order reducing the quota to 50% in all. This time around, the state did not provide separately for extremely backward category of backward category but made reservation in that behalf applicable to both categories. The reduced percentage of reservation provided was as follows: scheduled caste 10%, scheduled tribes 26%, other backward categories including both extremely backward categories and backward categories 14%, total 50%. Writ petitions were filed challenging the action of the state in taking away the separate reservation for the extremely backward categories and backward categories and providing for 14% reservation for other backward categories including both extremely backward and backward categories. The challenge was by those who claimed to belong to extremely backward categories, and their contention was that the clubbing together of the extremely backward categories and the backward categories would act to their prejudice and that the clubbing together was against the interim direction issued by the full bench. They argued that the percentage had to be reduced, but a separate percentage had to be assigned to the scheduled castes, scheduled tribes, extremely backward categories, and the backward categories as was done earlier. The state met this argument by contending that it was for the state to decide upon the quota of reservation and that there was nothing in the interim order of the full bench which restrained it from bringing within the fold of other backward categories both extremely backward and backward categories. It was submitted that it was a matter of policy and the government had fixed the quota fairly, and going by the modified interim order of the full bench, it was enabled to fix appropriate percentage of quotas with respect to each individual class and category as it may objectively and fairly decide constituting the sum total of 50%. In its wisdom, the government had decided that reservations must be made applicable to the classes of other backward categories and that the same should take in both the backward and the extremely backward categories. The learned single judge in the judgment under appeal held that, in the light of the decision referred to by him and in view of Article 15(4) of the Constitution of India, no person could claim any right of reservation in favor of the class or categories, and the state government was not bound to make separate reservation for each and every class of category. But the learned single judge took the view that the interim direction of the full bench precluded the state from recategorizing the recipients of reservations, and therefore the state had gone beyond its mandate under the interim direction by doing away with the separate reservations for the extremely backward categories and the backward categories. Hence, its order was unsustainable. Thus, the learned single judge set aside the subsequent resolution dated 10/10/2002 passed by the government in that behalf and remitted the matter to the state to determine separately what will be the percentage of reservations for the extremely backward categories and the backward categories for the purpose of the interim arrangement and for admission into professional technical institutions, subject to the final decision that may be rendered by the full bench in the earlier pending writ petitions. Though there were 3 writ petitions before the learned single judge which were disposed of by a common judgment, the state has chosen to file only LPA number 237 of 2003 against the judgment in the WPC number 6332 of 2003. Appeals have not been filed against the decisions in WPC number 6220 of 2002 and WPC number 6545 of 2002. An intervener claiming to be an association had sought to intervene in the writ petition, though no formal order was passed by the learned single judge in the petition for intervention filed by the intervener. Counsel for the intervener was also heard while disposing of the writ petitions. That intervener association has filed LPA number 176 of 2003 purporting to challenge the decision in WPC number 6220 of 2002. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.